So in the previous video, you got kind of a really basic overview of the concept of title insurance. When we represent a buyer, the contract basically says the seller must deliver free and clear title to this property at closing in order to convey it to our buyers. In addition to that, the title company who closes the transaction normally issues a title insurance policy, which basically more or less says, look, we reviewed all the public records. We made sure there were no defects, no clouds on title, no problems with the transfer of title to this property. And so we are willing to issue insurance that protects the title to this property. So if a divorced spouse from 10 years ago who used to be an owner of the property comes back and claims ownership of it, or if a roofer who put the roof on 6 years ago comes back and says he never got paid and he tries to put a lien on the property, your title insurance will step in and protect and basically defend against those claims and pay those claims if need be. Now, the way that you get evidence of title insurance, or the way they give you evidence of their intent to issue title insurance, is through what's called a title commitment. And you always get it from the title company, and I would say 90% of realtors out there never really look at it or understand it. But I'm going to show you three different title commitments, and I want to show you why you do need to understand what's on there and why you do need to take a close look at it when you're representing the buyer. This also will help sellers from time to time. If they have a cloud on title, you might be able to help them help themselves in terms of clearing that so that they can complete the sale. So without further ado, I'm going to jump over to a screen share and I'm going to show you some actual title commitments and talk you through sort of a case study that presents some red flags that you might want to keep in mind in the future. So there are actually a handful of companies who actually issue title insurance in the United States. And so you'll often see a title commitment either come from Fidelity, Old Republic, or First American Title. And they're all broken down pretty much the same way. And they start out with Schedule A. And Schedule A is really just going to show you who your buyer is, who the seller is, the legal description of the property, and who the lender is if they're doing a simultaneous issue of a lender's title policy in addition to the owner's title policy. And then Schedule B1 is the requirements. And basically what this says is we require the title company to do these things. All of the following requirements must be met in order for us to issue title insurance on this transaction. And so what you want to check here is just make sure that everything looks pretty routine. And what you'll typically see here is you need a deed, obviously transferring it from the seller to the buyer. If either one of those parties is an LLC, they're going to need proof that the LLC was in good standing as of the date of the transaction. So your title company will often ask for articles of incorporation and an operating agreement for the LLC if you're representing a buyer or seller who is doing so through an LLC or a corporation. And they'll also require that any mortgages currently on the property get paid off. If the property is being financed, they're obviously going to require that mortgage documentation for the current transaction. And so that's all routine stuff. If you see, yeah, they got to pay off the existing mortgages, they need LLC docs from the buyer and or the seller, they need the actual mortgage for the current buyer who's involved in this transaction. That all looks normal. Now, a red flag that you might see here is a really old mortgage. That would sometimes worry me. You'll see this one here. It says you must record in the public records a release or satisfaction of the mortgage from Wells Fargo in the amount of $115,000 from June 20th, 2013. And that's fairly recent. It's probably either when they purchased it or it might be a refinance or a home equity line. That's not a big deal. It looks pretty routine to me. However, if I saw on here record in the public records a release or satisfaction of the mortgage from, Bank of America from 1972, that would be a red flag, and I'd be on the phone to the title company saying, how is there not a satisfaction recorded of this mortgage from 1972? As you can imagine, getting a mortgage from 1972, getting a satisfaction document for that mortgage might be impossible. The lender could no longer exist, the borrower could be dead, and so that can present some challenges. And in the absence of being able to do that, what the title company will often do is go back to the previous issue of title insurance. And basically, the previous company insured it from their back, and so the current transaction is going to be insured from there forward. And so you'll often find yourself trying to find a copy of your seller's current or previous title policy from the previous transaction. The next thing you'll come to is Schedule B2. And Schedule B2 is what they call exceptions. And here they're saying we will insure the title to this transaction, to this property, against everything except this stuff listed here. And once you look at a few dozen title commitments, you'll realize that it's all pretty standard stuff here, typically. Basically, number one here says they're not going to insure anything that happens after today. They're basically insuring the title from here back. Number two says they're not going to insure the title against any claims that arise from the taxes for this year. They're not even due yet, or any subsequent years after now. So if this was issued in 2019, they're not going to insure against a claim on title because the 2019 taxes didn't get paid, or the 2020 or 2021 taxes. Those are happening in the future. So the title insurance policy covers everything from the closing day backwards. It does not go forwards. And then there are what we call standard exceptions, encroachments, encumbrances, violations, variations that would be disclosed by a survey. Anything that's not shown in the public records, if they didn't know about it and they couldn't discover it, they can't insure against it. And then taxes and assessments not shown in public records. These are all standard exceptions. You don't really have to sweat those too much. Now, I want to jump over here and show you a transaction that I did about 18 months ago. And when I got the title commitment, I looked at the exceptions, and I've highlighted them here for you. So these are exceptions. They're saying we will cover this title except for this stuff. And it said a certain code enforcement lien recorded in 2012, and then another code enforcement lien recorded in 2012. Our contract called for my buyer to have free and clear title to this property. The seller and the title company were trying to squeeze number 10 and number 11 into the exceptions on the title policy, and which would have basically made my buyer responsible for two liens dating back to 2012, which probably had accrued interest for several years. Could have been tens of thousands of dollars or more that they were trying to stick on the buyer here. So I caught that, went back to the title company and said, look, we never agreed to accept the property with these code enforcement liens. What that means is you, the seller, have to pay these liens at closing, and you, the title company, have to take that out of the purchase proceeds and pay off these liens so that my buyer gets free and clear title. And so that's an example of something that you really want to look out for is unusual exceptions in the title policy, because that basically means that your buyer is now on the hook for paying for it. And then just one other quick glance at a title commitment from First American, and they even highlighted it themselves from the title company under the requirements section on B1. You'll see here that they say payment and satisfaction of a mortgage in the amount of $160,000 from 2014. Again, that's another one that's pretty routine. And you can see, I can tell that the title company circled it and checked it off, meaning that they have the necessary documentation to close out that condition or that exception to the title insurance policy. So the big one is the requirements. If you see anything unusual in the requirements, like a mortgage from 1978, that sometimes can create a red flag. And then the really big one is in the exceptions. You don't want your buyer to accept any exceptions to free and clear title to the property in the transaction that you're closing. So that's really mainly the two sections you need to look at there is B1 and B2. And I'll be honest with you guys, this is primarily the title company's world. This is their job. but you need to have an awareness of it because title agents are not all perfect. They can miss things on here that maybe they didn't see, and you want to catch it early so that they can be working on it well in advance. You don't want to notice something 3 days before closing that's going to take you 3 weeks to fix. And then, frankly, not all title agents or title companies or sellers are as honest as you and I. And so they may be trying to slip something past you, like those exceptions for the code violation liens that I showed you in the previous one. This was sort of a wholesale deal. It was really being rushed, and I have no doubt that they were just trying to stick that there so that it would fall on the buyer to pay and make it a much more profitable transaction for them. And so be aware of what Schedule B1 and B2 are and what to look out for. And if you see anything unusual, pick up the phone or shoot an email to your title person at the title company and talk through the details and make sure you understand what they are doing to deliver free and clear title to your buyer.